Welcome. My name is Kathy Sager. I am a Senior Vice President with Canaccord Genuity. I'm happy to be here today with my fellow advisor and Senior Vice President Darcie Crowe to launch our series of educational webinars for women. We believe that knowledge is power, and we are here to empower you. Together, we've been advising clients for over 50 years. We are very excited to be launching this series, which will speak to the unique needs of women. Over the coming weeks, we will present various topics to educate women on all aspects of their financial lives and increase their confidence and security. Darcie?
Thanks so much, Kathy. So I'd like to take this opportunity to introduce our guest today. So today we have joining us Sally Dennis, and she is a partner at Farris here in Vancouver. Sally is a very experienced advisor on all things related to the transfer and protection of wealth. And she was actually just recently recognized by Best Lawyers in Canada as a leader in her space, which is trust and estates. So Sally, we're incredibly grateful to have you join us here today. Thank you so much for taking the time, and we're really grateful to have you to share your insights.
Thank you for having me. It's a pleasure.
Fantastic. So today we're going to be focusing on an issue that we very frequently have brought up from clients, and that's related to entering into second marriages, and particularly when there may be children involved from a former marriage. So Sally has graciously offered to take this opportunity to answer some specific questions that we tend to hear from our clients.
Well, let's start here. The first question we tend to hear is, I'm about to remarry, and I'm going to be forming a blended family with my children from a prior relationship. Is there anything I should be thinking about doing right away? What should my first steps be to ensure my assets and my children are protected?
That's a very good question. It sounds terribly unromantic, but I really would recommend that you consider entering into a marriage agreement at this point. Every marriage means something different to every couple, but for most people, it is a financial partnership of some sort. And in my experience, the first time around, it tends to be a partnership where what's mine is yours, what's yours is mine. But second time around, sometimes the environment is a little different. People are more mature, they've developed their own economic wealth, and they've learned a little by the experience the first time around, perhaps, particularly if the first breakdown has been adversarial. So I really would recommend that entering into a second relationship, where the approach might be more, what's mine is mine, what's yours is yours. You should consider getting advice on whether that should be documented and protected. So as I said, it sounds a very unromantic beginning to what should be a very positive stage in a person's life. But I really would recommend at least getting advice on whether that's something that's appropriate for you. Not in all cases would you want to have such a marriage agreement. A lot of this depends on the parties' relative wealth. Without wanting to sound too cynical, if you are the more financially secure partner going into this new partnership, you for sure would want to have an agreement. If you are the weaker party, it may not necessarily serve your interest to enter into an agreement. So I guess the bottom line is here, get some advice early on.
Okay, no, I think that's very, very sound advice. Thank you. One thing we're frequently asked about is joint ownership. So what's your views on, is it a good idea for clients to put assets, whether it be real estate, a home, or even investment assets, into joint ownership with their children?
Okay, well, perhaps I could step back a moment and just explain a little bit what joint ownership is, if that's okay.
Yeah, that would be great.
Yeah, so joint ownership means that, let's say, I'm going to use names here. So let's say we have Janet, who is the spouse going into the second relationship, and her children are Jack and Jill. Sorry, I just made up those names. So Janet owns a home. She owns a recreation property, and she owns some investments. And her children are in their young 20s. That's early 20s. Let's say that. So a joint ownership would mean that Janet would transfer the ownership of any of those assets into her name together with her two children, Jack and Jill. So now the three of them all own it together. And the result of it is that if any one of them were to die, the asset in question automatically goes to the survivors. So the reason why this is often a good idea is that, say Janet were to die, it would be very simple for all of those assets simply to transfer directly to her children. No fuss, no muss, no delay. It's all very straightforward. So it's often used as a strategy to facilitate what happens to a person's assets when they die. Also, incidentally, of course, it means that it goes directly to those children rather than to the second spouse in my example. But you really need to think very carefully about what you're doing before you do it, because if you add your children to any of those assets, they own them with you. Right now they own them. So let's take the example of the investment account. So now it's an account in the name of Janet, Jack, and Jill. Either Jack or Jill, in theory, could give investment instructions with respect to that account, could withdraw funds from that account, and they really are owners of that account. So that could pose some difficulties. I'm not sure I'd want my 20-somethings to have access to my investment accounts. Of course, I would warn my advisor that this is what I've done. Instruct them not to take instructions from my 26-year-old son. But that is one of the consequences of joint ownership. You really are jointly owning the asset. It means that you are jointly entitled to the income from that asset. It means you have equal say in theory into what happens to that asset. So I caution against doing it recklessly without thinking about those implications. Certainly in the context of your home, I would not recommend this. It's important from a tax perspective that you preserve your exemption from capital gain tax on your principal residence. That could be tainted by adding your children. I also suspect that the children wouldn't be willing to share the expenses of that home. They just want to share the benefits of it. So again, not something you do without a great deal of thought and consideration. And it varies from asset to asset whether it makes sense. If I may comment on the situation, say a recreational property, if you own the cabin at Whistler, excuse me, or a second property in Kelowna, and the purpose of that is for it to be a legacy property, you want it to go to your children. It is not to go to the second spouse. It's not to go to his children. It's to go to your children. And in fact, you currently share it as an asset that you're all enjoying together. Then it might make sense to put it into joint ownership with those children to assure that, yeah, when you die, it goes to your children. Another caution I would issue is that sometimes people die in what's called the wrong order. It sounds ridiculous, but if your children were to die before you, then you end up co-owning it with, say, just one of your two children, and you can have some very odd consequences if people don't die in the order you would expect. So I think probably that was too detailed of an answer, but is it a good idea? I guess my answer is the infuriating lawyer answer. Sometimes it depends.
Situational, yeah.
In some situations, though, Sally, we have clients who are adamant they want all of their assets to be left to their children. So they try and arrange things so that that's what happens. And I'm wondering if that's legal, if it can be challenged. Is it a problem later on?
Okay. Yes, I can understand that would come up quite regularly, particularly in the context of a blended family. I think the sort of nightmare for the Janet in my example is that on her passing, Jack and Jill get cut out, and the new spouse's children, in fact, get the benefit of all of her labors and wealth. So is it legal? Well, we have in British Columbia law that requires us to make provision for our surviving spouses and our children when we die. So if you were to arrange your affairs so that everything went to your children and you eliminated that second spouse, there is a risk that that second spouse would challenge the arrangements that you've made. So that is where I think people want to take steps to prevent that challenge from happening as much as they can. And is it legal to do so? Yes, you are allowed to arrange your affairs so that the people you want to inherit, in fact, inherit. One of the limitations on that is if your relationship is breaking down. So let's say your second marriage is already on the rocks, and you take steps then to put assets into, say, joint ownership with your children or into a trust, or you take other steps to prevent that spouse from having access to them, that could be challenged. But in the absence of an impending breakdown, you are entitled to take whatever steps you wish to circumnavigate those rules that give your second spouse the right to challenge.
Okay. So, and is there certain ways that clients can go about ensuring that their children receive their full inheritance, and particularly that won't be changed if the spouse survives them? And more particularly thinking, could the spouse's children perhaps challenge that?
Well, in almost no circumstances could the spouse's children have the right to challenge. Your stepchildren in a blended marriage, unless you adopt them, have no rights to challenge your estate plan. If you adopt them, whole different ball game. They then have the same rights as your own children. So, but stepchildren have none of those legal rights to challenge your will or your estate plan. So I'm not too worried about the children on the other half of the family. The second spouse, though, as I said, does have the right to be considered in your estate plan and be provided for, and could challenge if not. So some of the steps you could take are, okay, in the context of registered plans, for example, you could name your children as the beneficiaries, direct beneficiaries of those plans. There's absolutely nothing to stop you doing that. Might have bad tax consequences, but you can certainly name your children as the direct beneficiaries of your registered plans. If you have life insurance, you may want to consider naming your children to be the beneficiaries of those life insurance plans. So those direct designations mean that the assets go directly to your children, and there's no opportunity then for the spouse to challenge them. Other strategies would include putting assets into a trust of some sort. If you don't own an asset when you die, it's not governed by your will, and it's the will that your spouse can challenge. So if a trust owns your assets don't pass under your will, then there's nothing for the spouse to challenge. So there are various ways where you could achieve that. So that's one way of ensuring that there's no point in a spouse challenging your will, because there's no value in doing so. The assets have gone directly to your children.
Thank you. Sally, if the marriage were to break down, what should be done immediately in the area of estate planning?
Kathy, do you mind if I come back to that one and just do a little addendum to the previous question? I'm sorry. I'll come back to that. In a situation where you do wish to provide for your surviving spouse, to some degree, for example, you want him to get some benefit of your wealth for his lifetime, but ultimately you want the capital to go to your children. What you can do is set up a what's called a spousal trust, so that you're sort of putting a ring fence around the assets themselves. You can guarantee that the assets themselves, when your spouse dies, will go to your children and not his children. But in the meantime, he does get some benefit from those assets. So putting this in the context of an investment account, what he would get would be the income from that account for as long as he's alive. So you've made some provision for him. So he shouldn't be too pissed off. He shouldn't really be running straight off to court. You've made some provision for him. But what you've done is you've built this little fence around that account so that it doesn't go to him absolutely. So he can't give it to his children. When he dies, it goes to your children, and that's guaranteed. So you know that you've kind of done a compromise there. You've helped him out. You've reduced the risk of him challenging the arrangements you've made, but that account will ultimately go to your children as you intend. If you just left everything to him, as you might be inclined to do, or if you did it as a joint account, so it definitely would go directly to him, he can do whatever he wants with it when you die. He might say, darling, I would never do that. I love your children. I would never cut them out of my will. Your two children, my two children, they're going to share everything 4 ways when I die. But then you die, and he changes his mind. If he owns that account, 100% owns it with no restrictions, he can leave it to his children. And your children, since he hasn't adopted them, have absolutely no rights to challenge that, and that account is lost. It's gone to the surviving spouse. If you go the spousal trust route, you've given him an income stream, but when he dies, his children have no access to that whatsoever, and it must go to your children. So that's a very common strategy, and it has the benefit of also being tax efficient, because capital gains won't be triggered on your passing. They won't be triggered till he dies. So you get the benefit of the spousal rollover that you would have with the spouse, but also the added security that your children will ultimately get that account. So
So
sorry.
Sally, would that work for a home as well? You could leave the home into a spousal trust so that the surviving spouse has use of the home until they pass, and then it would go to the children?
Absolutely, you can do it for the spouse too. Now, there are some difficulties with preserving the principal residence exemption in that instance. And because a number of rules have been introduced to limit the access that a trust in that instance would have to the home. But there are steps that can be taken to preserve it, and it would depend on the circumstances, but it can be done. Yes.
Okay, great.
Okay, so now we're being negative and the marriage has dissolved. Now what do? How do we deal with estate planning when we're faced with the dissolution of a marriage?
Okay, so if it's starting to break down, and you would like to start putting assets into trusts and do other things to protect against the things we've been talking about, if you actually have a breakdown on your hands, it's going to be a little late to start moving assets around, because that spouse is going to be able to argue that you did it deliberately to deprive him of his access to your assets on a marriage breakdown. So some options are limited there, but what you should be doing, of course, if you have a marriage agreement in place, you don't need to worry about that. But let's assume you don't have a marriage agreement in place.
Right.
You certainly should be looking at making sure that the designations on your registered plans have been updated. This is something that tends to be forgotten. Marriage breaks down, people assume that those just get revoked. They don't. You actually have to change those beneficiary designations. So if you have named your spouse as the beneficiary of your RSP, your TFSA, or your insurance plan policy, you should be changing those. That would be almost like my first step if my marriage is breaking down. From the point of view of changing your will, it would probably make sense to get your will updated. That being said, our laws do provide that on a marriage breakdown, if you've appointed your spouse as the executor, that gets revoked. And if you've left your estate to your spouse, that gets revoked. So the law helps you there a little bit, but it's a lot cleaner to get your will updated. So I certainly would do that if, depending on what your will says, of course, at the moment. If you've set up one of those spousal trusts that's giving that spouse an ongoing income stream, you may no longer be feeling quite so generous. So you would probably want to get rid of that spousal trust.
Thank you, Sally. Today has been wonderful. We appreciate your time. It's been very educational. If anyone out there has any questions that we did not get to today or further questions, please contact us and we'll make sure we get the answers for you. Thank you.
Thank you. And yeah, thank you everybody for joining us today. We're going to continue to host these information sessions. So we really appreciate any feedback that you might have or topics that you would really appreciate us covering in the future. We really want to make these as informative and insightful and useful as possible. So any ideas or feedback that you have, we would absolutely love to hear from you, and we would certainly hope to cover them in the future. So thank you everyone for joining us. Again, thank you, Sally, so much for your time. We greatly appreciate it, and wishing everyone a wonderful day. Take care.